Good evening, everyone, and welcome guests, alumni of the law school, alumni of IJA programs, and other welcome guests, distinguished judges, and former Brennan lecturer. I'm so glad to see Chief Judge Kaye here. The Brennan Lecture is sponsored each year by the Dwight D. Opperman Institute of Judicial Administration, of which myself and Troy McKenzie and Sam S. Stryker are the executive directors and faculty directors, and Evan Chesler from Cravath is the chairman of the board. A brief history. For more than 60 years, the IJA has played a major role in judicial education, outreach to the legal profession, and empirical and theoretical research concerning the justice system. And we are proud to say, as a university-based educational research organization, we seek to bring the worlds of practice and theory together rather than advancing a particular ideological position. It is remarkable but true that 1/3 of all federal and state appellate judges are alumni of the IJA summer program for appellate judges, for new appellate judges, which is now well over its 50th year of educating judges. As to the Brennan Lectures, we are very proud to sponsor the Brennan Lectures because it is an opportunity to hear from and honor state court judges of note. We hear a lot about federal courts. We have the Madison Lecture, and it's great that we have the program that the Brennan Lecture brings to us. And it honors, of course, Justice William J. Brennan, who, as a great Supreme Court justice, is, of course, very well remembered, but sometimes overlooked was that he was for a long time a member of the Supreme Court of New Jersey and was a pathbreaker on state law issues as well as on federal constitutional issues. So we've had a marvelous group over the years of Brennan Lecturers. We're so happy that Chief Justice Rogers will be with us tonight, but my somewhat limited role is to introduce the introducer, who will be Chief Justice Jonathan Lippman. I am happy to say a member of our board of directors and a source of wisdom and guidance in many, many, many areas. Now, it's often said someone needs no introduction, but then people usually follow with an introduction. And of course, I'm going to do the same thing because our Chief Judge needs no introduction. But we are happy to welcome him, not only because of his many achievements, but also he is truly part of the NYU and IJA family. He's an alumnus of the law school, and as I said, a member of the IJA board, and a great booster and advisor for the program. As Chief Judge, of the New York Court of Appeals, he, as I'm sure most of you know, succeeded Chief Judge Kaye, also an NYU a graduate. And so, as it's sometimes said, this is a little self-pumping for the law school. Every Chief Judge of the state of New York has been an NYU alumnus over the last 20 to 25 years. And they're both sitting here tonight. And we are very, very proud of that. Of course, Chief Judge Lippman has been remarkably active and thoughtful in many modern contemporary issues that he's taken on. Reform of legal education, which we have felt already at the law school and moved us forward in different ways. More recently, changes in grand jury procedures that he's suggested. And as he stressed in his own Brennan lecture last year, the importance and ways of dealing with the justice gap for that so badly affects people of little means. So please welcome our Chief Judge of the New York Court of Appeals, who will introduce our speaker.
Thank you. It's a delight to be here, and in particular have my colleagues here, past and present. Judge Susan Reed, the Senior Associate Judge of the Court of Appeals, Robert Smith, the just finished Associate Justice of the Court of Appeals till the end of the year, and of course, the first Brennan lecturer, my predecessor, the great Chief Judge Judith Kaye. I am on my way to 2 other events tonight, but I could not and would not miss the opportunity and the pleasure and the honor of introducing tonight's speaker, Chief Justice Chase T. Rogers, as she delivers the 21st Annual William J. Brennan Jr. Lecture on State Courts and Social Justice. This year's Brennan Lecturer is truly someone who stands out among her peers. Chief Justice Chase Rogers is a superb leader of the Supreme Court in Connecticut and the judiciary who has confronted challenges to her court with energy, creativity, judgment, and intellect. And those challenges have been formidable. Connecticut, like New York, and so many states around the country, has seen its judiciary budget slashed and workforce reduced in recent years. At the same time, the number of unrepresented litigants in the courts, especially in family and housing cases, places a tremendous burden in Connecticut as it does here. Chief Justice Rogers uniquely understands that in this context, where equal justice is threatened, leaders of our judiciary cannot take a business-as-usual attitude, and rather must embrace change. And that is exactly what she has done and what she will talk about tonight in illuminating the rethinking and restructuring that Connecticut's judiciary has done to provide meaningful access to justice. Justice Rogers grew up in Connecticut, although born in Manhattan, I might add, traveled to California for college at Stanford, and came back to New England for a law degree at Boston University. On returning to Connecticut, she went to work for Cummings and Lockwood, where she practiced commercial and employment litigation for 14 years and oversaw the firm's pro bono program, demonstrating long ago the compassion and concern for access to justice that she brings to the job of Chief Justice today. In 1998, she was nominated by Connecticut's governor to the Supreme Court, to Superior Court. The Supreme Court here is not supreme. In Connecticut, it is supreme. To the Superior Court, Connecticut's Trial Court of General Jurisdiction, where she presided over juvenile, child protective, and civil matters. In February 2006, after 8 years on the trial court, Justice Rogers was nominated for Connecticut's appellate court, and shortly thereafter, Governor M. Jody Rell nominated her to be Chief Justice of the Connecticut Supreme Court. Governor Rell recognized Chase Rogers' great skill, not just as a jurist, but as an effective administrator and leader. Her confirmation was met with great enthusiasm from elected officials and fellow judges who described her as extraordinary, remarkable, warm, decent, pragmatic, possessing integrity and character, and handling herself with poise, thoughtfulness, and a keen knowledge of the law. I concur and affirm from firsthand knowledge each and every one of those descriptions of Chief Justice Rogers. Beyond her obvious intellect and judicial skills, Chief Justice Rogers is also a tireless leader with a deep commitment to public service and a vision for a court system that is accessible, open, efficient, and fair. As Chief Justice, she created the Public Service and Trust Commission to find out what the public wanted from their court system, established a pro bono committee to increase volunteer service by the bar, formed the Standing Access to Justice Commission with a mission to develop recommendations to help ensure equal access to justice, and implemented reform after reform with an eye to better serving all who visit the courts. She has championed judicial independence, including an essential pay raise for judges, jury reform, alternative dispute resolution, changes to procedures in foreclosure cases, e-filing, and improvements to the complex litigation docket. It was Chief Justice Rogers' vision that also led to the creation of Lawyer Corps Connecticut, a program that funds recent law school graduates to provide legal aid to the poor, a program that I so greatly admire and that I referred to in last year's Brennan Lecture as one of the breakthrough access to justice innovations in the country. As much as she has done in Connecticut, Chief Justice Rogers has shared her talents on the national stage. With her colleagues on the Conference of Chief Justices, where she sits on the critically important Civil Justice Initiative Committee, where she is working to find best practices and new ways to promote the timely and cost-efficient resolution of civil cases, as an appointee of the President of the United States on the State Justice Institute, fostering innovation in state courts around the country, and as the appointee of Chief Justice Rogers on the Committee on Federal State Jurisdiction of the Judicial Conference of the United States, and so much more. Let me sum it up this way. Chief Justice Rogers has written the script for judicial competence, court leadership, innovation, and a commitment to the pursuit of justice in Connecticut and state courts around the country. To me, she is truly a kindred spirit, someone who invariably looks to new solutions for the many challenges facing the courts and recognizes that every single person, rich and poor, high and low alike, is entitled to their day in court. I know that you're in for a real treat tonight in hearing Chief Justice Rogers speak on keeping courts relevant in the complex world we live in, as she totally and absolutely in character rejects a one-size-fits-all mentality for resolving court cases. I am very proud to introduce to all of you at what we like to call the law school, my friend, the Chief Justice of Connecticut, Chase T. Rogers.
Thank you. Have a good evening. I'm going to ask you if you can come to my renomination and reconfirmation hearing. It's in 2 weeks. That would be very helpful. All right. Well, good evening, everybody, and thank you for coming. Let me begin by saying what a tremendous honor it is to have been asked to deliver the 21st Annual William J. Brennan Jr. Lecture on State Courts and Social Justice. I am well aware of both the intellect and innovation that my predecessors in giving this lecture have brought to the table, and my goal this evening is to push the boundaries and provoke at least some percentage of the thought that resulted from those prior lectures. And this is going to be particularly difficult given that last year's Brennan Lecture, Chief Judge Lippman, represents to really all of the Chief Justices throughout the United States, probably the most progressive thinker in the area of administrative reform. He set the bar extremely high, but I'm going to do my best this evening. The intersection of changes in society and the judiciary's ability to provide access to justice is certainly not a new revelation by any stretch. However, I would submit to you that our historical response must dramatically change if we're going to continue to provide meaningful access to justice. In this regard, I am going to limit my remarks tonight to procedures in the civil justice system and not wade into the waters of criminal justice. In beginning this discussion, I want to emphasize that we are not talking about access for access' sake. Instead, it's essential to provide a pathway for people where we can assure that justice is being achieved and not falling by the wayside because someone doesn't speak English, doesn't know what papers to file, doesn't know what arguments to make, or simply doesn't understand what the purpose of a hearing is. And I'd like to start this evening by getting a show of hands from those of you who have been out of law school for, say, longer than 20 years. Okay, all right. And how about a show of hands from those of you who are still in law school or just a few years out? Okay, it's about half and half. Well, if we vintage law school graduates, and note I didn't raise my hand either way, were to sit down with you newly minted law school graduates, my guess is that our conversation would quickly turn to the remarkable changes that have occurred in our courts since we graduated. And let me start with just a few examples that illustrate why we must make changes to how we conduct our business in the judicial system. The first change is advancement in technology. As we know, people in the United States are plugged in and expect to do much of their business through computers and the web. And it was approximately 10 years ago that some states began implementing e-filing of court documents. And now, for instance, in Connecticut, all civil and family case filings are e-filed, and our judges issue most of their rulings electronically. Throughout the country, judicial websites include databases with online case lookup and a whole menu of information, including forms and tutorials in multiple languages. In the past, people had to go to courthouses to access this information, where in all likelihood the only language being spoken by judicial staff would be English. Now, technology has provided us with the ability to communicate in approximately 170 languages through the use of technology called LanguageLine, either by phone or in person. All of these technological changes have created efficiencies and exciting opportunities for the administration of justice, which I'm going to discuss further in a few minutes. Turning to the second major change, the societal environment in which we live has also changed dramatically. Specifically, and I know that Chief Judge Lippman talked about this last year, one change that we have witnessed is a large and growing economic gap in this country, which has resulted in a myriad of problems for people, such as the recent foreclosure crisis and a rise in debt collect actions in state court. This economic gap is partially responsible for the final major change in our court system that I am going to focus on tonight. Namely, that there are more self-represented parties in our courts from California to Connecticut than ever before. People are representing themselves in family and civil matters in astounding numbers. And again, just looking at Connecticut, in family cases, 85% of the cases have at least one party who is self-represented. And in civil cases, approximately 26% have one self-represented party. And perhaps most shocking, at the intermediate appellate level in Connecticut, 38% of the cases have one self-represented party. So, ladies and gentlemen, I would submit to you that this would have been unheard of when I graduated from law school. We know, however, that if we're to ensure that people continue to believe in the justice system and rule of law, we must provide meaningful access to justice for everyone, including those people who are representing themselves. So how do we ensure continued meaningful access amid all these changes? How do we effectively and efficiently continue to meet our obligation under the social compact that we have with the people we serve so we can continue to have their support as a branch of a democratic government? And the answer I would submit is this: we need to change the mindset that has defined for centuries the process by which we handle civil cases. When my contemporaries and I went to law school, all of our training was in the context of an advocacy system that culminated in a trial. The key players always included 2 attorneys, 1 per party, and a judge, regardless of the complexity or the merits of the case. It was a nice one-size-fits-all way of approaching cases that worked. But what I would submit to you is it is completely ill-suited to our 21st century court system. Put another way, our court system is founded on tradition and precedent for a very good reason, and I'm not speaking, obviously, tonight about decisions that we actually render. Instead, I'm talking about the process by which we get to the ultimate resolution of a matter. I'm pleased to report to you tonight that this discussion is well underway at the national level. As you may know, Chief Justices from all the states meet regularly to discuss issues of mutual concern and to provide education regarding possible solutions. In 2013, the Conference of Chief Justices passed a resolution creating a national committee to focus on civil justice. And as a member of that committee, I can tell you that we have been very hard at work over the past year to identify common issues, best practices, and new ways to provide timely and cost-efficient resolutions to civil cases. It's been an exciting project that's been funded by the National Center for State Courts and the State Justice Institute, and we've been working under the able leadership of Oregon Chief Justice Thomas Balmer. Based on our progress to date, I'm absolutely certain that the committee's final product will be useful in our individual states as we all look to ways to improve our civil justice system. I think it's fair to say that the first important change is one of focus, in which court systems recognize that the goal is not just to expedite matters. Rather, we must also take some responsibility for helping to reduce the amount of money it takes to resolve a civil or family case. The additional benefit of reducing costs is that people will then hopefully hire legal counsel for at least a part of their court matter. At the same time, we must also recognize that some people will continue to represent themselves in court proceedings, and we have to do everything that we can to ensure that justice is being done in those cases. And let me take a step back here and say there's no question that the bar must find ways to reduce the cost of representation. In fact, the National Center for State Courts recently conducted a survey in which the cost of hiring an attorney was perceived to be the greatest barrier to access to justice. Having listened to the current ABA President Bill Hubbard recently speak, I can tell you that bar leadership is seriously trying to come up with their own solutions so that lawyers will remain relevant in the 21st century. We now recognize, however, that while we must look forward to seeing how the bar addresses this problem, we in the judicial system must also be part of finding a cost solution. Finding ways to make the process less expensive, therefore, has been a recurring theme in much of the work that the National Committee has been doing so far. So the question is, how do we reduce cost? And I want you to consider the following scenario. There are a lot of judges in this room. You're a judge in a civil courtroom, one of the more experienced judges on the bench in your state. Half of your day is spent on handling discovery motions on a docket consisting of slip and fall or minor motor vehicle cases, and you know you've got several more complicated cases in the mix, including working on a motion for summary judgment in a complex commercial matter that all needs to wait until you get through that morning docket. As the day wears on, somewhere among the myriad cases before you think, is this really an efficient use of judicial resources, not to mention the attorney's fees or wasted time that the parties are incurring waiting for an argument regarding discovery in their matter? What we are finally starting to recognize is that one size no longer fits all. We need to find a way to distinguish the straightforward case that comes into civil court from those that require more judicial involvement. Of course, I'm not suggesting here that some cases are unimportant. We all know that for the parties, their case is very important, regardless of the circumstances. Yet when it comes to managing a docket, it's important to categorize which cases should take more judicial oversight and time, and which ones should take less. If we're simply processing a docket and not effectively managing it, then we run the risk of far too costly outcomes. The Civil Justice Initiative Committee is operating from the same premise as our hypothetical judge sitting on the bench worrying about the necessity for him or her to oversee certain stages of the process in certain types of cases. Essentially, what we're talking about is aligning our judicial resources so that a civil case may be handled in the most cost-efficient way from the moment of filing all the way through its resolution. In this regard, the committee has been looking at developing a system which would segregate cases into 3 different pathways, each with a process that is tailored to reach an efficient resolution of those types of matters. The thinking is that not all cases require the same level of discovery and judicial management. If, for example, a case is a simple debt collection matter, why require the parties to follow the same procedures that are in place for a complicated medical malpractice case? It really doesn't make any sense at all and necessarily results in increased costs. This 3-pathway approach conceptually can be identified as streamlined, standard, and complex. When a case is initially filed, it would be slotted by case type into one of the 3 tiers, and parties would have to file a motion to be placed in a different tier. Streamlined cases would require little judicial oversight, which by way of example may include slip and fall, debt collections, and appeals from small claims. The thinking is that there would be different procedures in place for these cases to limit judicial involvement and discovery in order to resolve cases efficiently. For instance, there would be mandatory and limited discovery that would be exchanged almost immediately upon filing. There may also be simpler rules and less time contemplated for resolution of these types of matters, including limited trial length. Interestingly, a majority of the cases we handle in the state courts fall within this category, and many of these cases involve people who represent themselves. A simpler process with less motion practice can only improve access and our corresponding ability to provide justice. The second group, which has been described as the standard pathway, is being defined as all of the cases that fall in between streamlined and complex. These are the cases that require some regular judicial management and oversight, but don't rise to the level of a complex case where discovery and judicial involvement is extensive. Again, we anticipate recommending that there would be mandatory disclosure of all evidence proportional to the case and early judicial involvement to set up a schedule, including a firm trial date to take place within approximately 12 months of filing. There would be intelligent use of technology, such as video conferences or phone calls, to handle matters that arise, and a judge may require such a conference to preview whether a discovery dispute needs to be filed in writing or instead can be resolved right then by way of the conference. While it is far more controversial, and they actually asked me not to mention it, but I will anyway, we are also considering whether judges may want to preview through a conference whether a summary judgment motion should be filed at all in a particular case. As I've already mentioned, the last category would be those complex cases that are labor-intensive for judges, court staff, and the parties. These cases generally involve more discovery, more complicated legal issues, and more regular judicial involvement by a single judge who is familiar with the discovery and legal issues in a particular matter. Fortunately for us, a number of states have extensive experience with this type of docket because they have already carved out a complex litigation docket. By setting up these pathways, we can use judicial resources more effectively, allowing judges to spend more time on the cases that should actually require more of their time. This is just common sense in terms of court management, but it's also a major change that not everyone, including some members of both the judicial branch and the bar, will embrace initially. Fortunately, we've already learned from some states' experience what changes in procedure appear to work well and where problems may arise. For instance, what we're seeing is that states that have utilized different types of case management are teaching us that the best practice is to require opting out, not opting in to a specific tier, because some lawyers are reluctant to opt in because of concerns about limited discovery. We have also found that cases should be tiered by case type, not dollar amount, because some lawyers will overstate their damages to, again, not be limited in discovery. I must mention that as a committee, we continue to discuss and develop a list of best practices, so what I've mentioned tonight may not all make it into the final recommendations. We do plan to roll out our final recommendations to the state courts early next year. So on a national level, I think it's fair to say that we are on the right track in developing a plan. What I'd like to do now is turn to a few other changes that are being made at a state level in Connecticut to restructure our court system with the goal of providing relevant, affordable, and accessible service. We began by examining more closely how we do our civil business in Connecticut about 2 years ago, with the goal of making the best possible use of our resources. As was mentioned before, we have had fairly significant budget cuts over the years. We began by examining more closely how do we do our civil business in Connecticut. And we started the process of restructuring the civil justice system in Connecticut by conducting 5 focus groups comprised of really all of our stakeholders. As a result, we identified 4 general areas to focus on in our restructuring efforts. They were improving litigation management, confronting current discovery issues, enhancing alternative dispute resolution options, and looking at the needs and impact of self-represented parties. With regard to the first 2 categories of improving litigation management and confronting discovery issues, just as we had identified on the national level that we have to manage our dockets differently depending on case type, what we learned from the focus group was this: it is not just a timely resolution that's important. Over the years, we have made changes that allow virtually any civil matter in the state to be tried within 12 months if the parties want to. So getting to a resolution is not the issue for us. Instead, it's essential to examine the entire process of reaching that timely resolution. As a result, the proposal of a 3-tier system and the requirement of automatic and proportional discovery on a national level are under serious consideration in Connecticut. I see several Connecticut lawyers having a heart attack, so I won't look at them anymore. I want to mention several additional changes that are happening. One of the most significant changes that we've already made has been to implement individual calendaring for most types of cases where one judge is responsible for a case from start to finish, instead of multiple judges handling pretrial matters. My guess is that those of you who practice exclusively in the federal courts are surprised to hear that multiple judges may be handling different aspects of a single case. The reality is that many states have this system, mainly because our dockets are so much larger than the federal system. By way of example, in Connecticut last year, we disposed of over 500,000 cases in our trial court. Despite the difficulties in managing such a large docket through individual calendaring, we're excited that this change is occurring in Connecticut and confident that individual calendaring will enhance the consistency and the predictability of rulings on motions and discovery disputes and increase the possibility for settlement because parties will have a judge who's familiar with the law and the history of the case. We also plan to continue to take advantage of technology. By way of example, instead of filing and arguing motions, the parties now are able to resolve many pleadings and discovery disputes through status conferences by phone or video conferencing, thereby saving lawyers and parties a lot of time and money. In addition to changing our pretrial case management, we're also enhancing our alternative dispute resolution services. This initiative has been in the works in Connecticut for some time. While the traditional role of the courts is to resolve disputes through a trial, we all know that the vast majority of cases settle as opposed to being tried. And I therefore believe that if we're going to stay relevant, we need to also provide a high level of alternative dispute resolution. Not surprisingly, in-house counsel and lawyers are now telling us that arbitration and private mediation are not the mecca that they had anticipated. Instead, they're telling us that arbitration is turning out to be costly and unpredictable, and the private mediation is even more expensive. As a result, they are willing to return to the court system if they can expect a high level of service. And I see this as a great opportunity. And in our system, we have worked to simplify the process of requesting and scheduling judicial alternative dispute resolution sessions. We have also increased statewide the number of judges available to mediate cases and have ongoing judges' education programs that focus on mediation models, techniques, and strategies to resolve cases through alternative dispute resolution. Obviously, without highly trained judges, we cannot succeed in this area, particularly since judicial mediation requires a completely different skill set than presiding over a trial. We're also looking at the idea of creating an actual mediation center and docket, which potentially could ensure that effective and skilled mediation is widely available for all parties, not just those who can afford private mediation. This center may mirror what is available in the private sector with, for example, multiple conference rooms and extended hours. The significant difference, of course, is that this service would be free, thereby making it accessible to all. The need to come up with best practices and dedicated resources in the area of alternative dispute resolution is again based on a recognition that the court system cannot continue to do business as usual. Progress in this area is critical because the bottom line is this: mediation resolves appropriate cases more efficiently at an earlier stage in the process and at considerably less cost to the parties. Finally, I want to turn to the remaining focus area in Connecticut and one of the major changes I identified for you in the administration of justice, addressing the needs and impact of the ever-increasing number of self-represented parties in our court system. This phenomenon is directly impacting access to justice, and you simply cannot consider restructuring court processes without considering them. Of the approximately 26% of civil cases in Connecticut which have at least one self-represented party and the 85% in family cases, we know that some of them have no choice because the cost of legal representation is too high. We also know that others who may have resources to hire an attorney believe they can navigate the court system effectively on their own. Either way, I would submit to you that that reason is immaterial. The self-represented population is increasing, and we must find ways to improve their access to justice while at the same time being aware of the impact on judges, court staff, attorneys who are trying to represent their clients, and the entire justice system. To address the needs of self-represented parties, the Connecticut Judicial Branch for many years has been committed to a variety of programs. Some are focused on helping self-represented parties navigate the system, and others are geared to identifying ways to try and find legal representation for these people. By way of just a few examples, with regard to people who can't afford an attorney or just decide to go it alone, our court service centers and public information desks are in every judicial district. And last year, they were utilized by self-represented parties 262,527 times. In addition, material and forms on the judicial branch website are being revised and simplified on an ongoing and daily basis and translated into multiple languages. We have also developed online tutorials and guides to assist self-represented parties in defending lawsuits. These services help, but we all know, everyone in this room knows this, that under our current civil system, justice is better served if people are represented by counsel. In this regard, we have worked hard, hand in hand with our legal aid community, to increase its funding. We've also concentrated on making more legal representation available to those individuals who cannot afford an attorney. For example, we have passed rules to make it possible for clients to hire attorneys to file limited scope appearances to represent them in at least the most crucial proceedings in their case. For those who cannot afford an attorney at all but want some assistance, volunteer attorney programs in the area of foreclosure, domestic violence, and family law have been established. With the continued generous cooperation of the bar, we anticipate expanding these programs. And additionally, as Chief Judge Littman mentioned, one of the more exciting developments we've seen is the creation of Lawyer Corps Connecticut, which is roughly modeled on Teach for America. The genesis for this program was about 2 years ago when I started trying to think of ways to engage the state's business community on this issue. And I reached out to the leaders in the business community and I asked for their help. And today, I'm pleased to report that United Technologies and General Electric, as well as other corporations in Connecticut, are sponsoring Lawyer Corps Connecticut, which provides new attorneys with the opportunity to receive a fellowship to work for a legal aid organization in Connecticut for a 2-year period. Of particular importance is that the funding for these positions comes from the business community as opposed to state government. And legal aid will supervise the new attorneys to make sure they are providing excellent legal representation for their clients. As you can see, this is a win-win all the way around. In the short term, those in need will receive direct legal assistance. And in the long term, our justice system reaps the benefit of a new generation of attorneys whose career path, we hope, is geared towards, at a minimum, providing some real pro bono service. Finally, we've also spent a great deal of time encouraging attorneys to do more pro bono service, and in 2011 and 2014, the judicial branch organized summits to brainstorm ideas and energize attorneys who want to help the disadvantaged. Again, we asked, and they came. The results have been excellent. Some of the attorneys who attended have been incredibly dedicated in terms of developing their own signature pro bono programs for their law firms. Just as one example, there is now a cooperative pro bono project to provide medical and legal intervention for indigent clients in domestic violence cases. As one last example, I'm especially proud of the Young Lawyers section of the Connecticut Bar Association. It stepped up to the challenge through its pro bono service campaign, which ran from March to May of 2013. The number of pro bono hours performed in connection with the campaign was double what was anticipated, equaling more than $2 million worth of pro bono services. Finally, the need for legal representation is perhaps clearest at the appellate level. Simply put, how is a non-lawyer supposed to identify issues, write about, and ultimately argue effectively in support of their case? In this regard, pro bono appellate lawyers are looking at a number of different ways to help, and specifically looking into the viability of having an attorney of the day program to assist self-represented parties in navigating the appellate process rules and to talk to them about what arguments might be the most persuasive for an appellate court. Yet with all of these efforts, there's still a lot of work to be done. Self-represented litigants have changed our legal landscape and will continue to do so for the foreseeable future. We have no choice but to continue to explore ways to make the system accessible to them in order to ensure that we are achieving our ultimate goal of justice for all. All of the changes on both the national level and in my state that I've discussed tonight do not happen easily. At this point, however, it's clear that we're going to have to rely heavily on technology and extensive changes in case management to achieve our goals. And the irony is that by adopting changes in our courts, we ensure that the fundamental principles that make the courts what they are in this country will never change. In other words, by evolving to meet the needs of today, we ensure that the rule of law and the public's trust and confidence in us to provide meaningful access to justice will remain strong. It would be interesting to know what the speaker will be saying at the 2035 Brennan Lecture, and I can't even envision what challenges will exist 20 years from now, and it's going to be up to a new generation to figure it all out. I can tell you, however, that current Chief Justices throughout the United States are vigilantly trying to make sure that a fair and accessible court system will be available to the public in 2035. In closing, I hope I've provided you with some ideas to bring back home, and I look forward to hearing your thoughts. So thank you again for the tremendous privilege of addressing you this evening, and I'd be happy to answer any questions you have. So any questions? Clear as a bell? All right, well, thank you very much. Thank you.
Thank you, Chief Justice Rogers. I've learned from teaching law school, at law school for many years, you've got to wait longer for the, but it reminds me of my class, but I won't say which class because there might be some people here from it. Thank you so much for a really interesting, provocative, and thoughtful talk. We are now, I think the reception table is open, and I hope people will stay around, talk to the many interesting people here, and perhaps offer some questions to Chief Justice Rogers during the reception. Thank you all for coming.